Number 5.
Next, we go to a child custody hearing in Las Vegas, Nevada. The plaintiff is Shelby Bachman, and the defendant, Jonathan King. The couple are arguing over visitation rights for their 2-year-old son, Joseph. The issue is King's unpredictable work schedule. The attorneys are Don Prokopius, and for the defense, Machancy Kramer.
Because my client is a UPS driver, his schedule, though, is not a set schedule. It varies. So he has to keep her notified of when his schedule is changing so that she's aware of pickup. She has told him now if he's more than half an hour late, he forfeits his entire weekend and can't see the kid.
Has Joseph gone weekends that he would have expected to see his father without seeing his father?
He has not missed one weekend. Not one.
The threat was made.
I
Not
didn't
one.
ask you if the threat was made. I asked if it happened. You led me to believe that it was happening.
No.
My client has worked with him at times that it was till Saturday morning that he picked up.
There is a problem here.
After hearing from both sides, Judge Sandra Pomerantz points to the lack of cooperation between the parents.
What I see here is parties not being creative. But these two need to be adult enough to say, okay, this happened, where do we go from here?
But Your Honor, and I agree with you. And so what she's done is on these times where she's worked with him, but then I think it was within the last 2 weekends.
I thought you said you agreed with me.
I do agree with you.
Okay,
that
so
is that
listen
judge.
to me. You're going to be done with this case when this case is over and these parties are divorced. They'll never be done with this case. Okay? So rather than complaining to me, it's a discussion with Mr. Prokopius being creative.
It appears the judge has struck a nerve with the defense.
My client has come up with all kinds of solutions, Your Honor, and it comes down to what mom wants is what mom is going to demand.
Okay, I don't buy that.
Well, Your Honor, that's how it is.
What I'm telling you is, have you discussed this issue with Mr. Prokopius?
Yes, I have in the hallway.
Okay. And has it been a matter of making demands or saying, what are we going to do?
No, it's a matter of
been
calling
a
my
matter-
client
Things begin to get personal, and the judge has a few words for Kramer.
I do have experience with you using inappropriate language.
And you know
toward
that I
her.
would admit it if I had done it. And if I was going to do it, I would have done it to her face.
You know what? You want to be a sailor, fine. Go be a sailor in your private life. But don't be a sailor in my court or in my cases.
I didn't.
Again, I don't judge people with sailor language because I use a little sailor language, but only in my private life, not in my courtroom, not to a litigant, not to an attorney. I don't do that because that's not professional. And ma'am, I warn you, one of these days, the State Bar is going to catch up to that. Because if you read the rules, there is an ethical rule about fairness to opposing counsel.
I know that there are also rules about treating people equally without regard to race, ethnicity, or gender. I find it highly objectionable that anyone complains about my language because I know all kinds of male attorneys who have no problem picking up the phone and screaming cuss words at me. So if I am outside there where my First Amendment rights are in full effect, I will say what I choose to say when I choose to say it, and that is my right in this country.
Are you done?
But after a few minutes of civility, the counselor starts up again.
We've spent, 5-10 minutes talking about nothing that is relevant to this case because I, as a female attorney, am being chastised over language that men feel free to use every single day, and they do.
You are giving me a headache because you're yelling, and I don't like having a
Well, I'm
headache.
being attacked, Your Honor.
No, you're not. Sit down, counsel. I'm done hearing from you.
Unsatisfied with the parties' solutions, the judge orders an evidentiary hearing, which means the parents will submit evidence against each other and the judge will make a ruling. In a child custody case, it can get ugly.
Your lawyers are going to be painting a picture for me in court. And it's not going to be a great picture of either one of you about the other.
Even after the judge makes her decision, the defense tries one last argument.
Your Honor,
I have nothing more to say, and I want to hear from either one of you. I'm going to set the trial.
I understand that.
So sit down.
The couple's evidentiary hearing is postponed multiple times and has yet to be heard.
Number 4.
Next, we're in Denver, Colorado, for the deposition of attorney Robert Abrams. Abrams' firm was added as a defendant alongside their client in a lawsuit between two former business partners and are being sued for fraud, conspiracy, and aiding and abetting a criminal by the plaintiff.
Good morning, Mr. Abrams. Do you understand why you've been asked to give your deposition today?
No.
To say tensions are high in the room would be an understatement. Asking the questions off camera is the plaintiff's lawyer, Tom Werge. And on the other side of the table is Abrams' lawyer, Neil Sullenberger.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month?
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath. You have no idea whether you've been deposed before?
I've answered that question. Object to form. Move on.
Object to form is a quick way to object during a deposition and, in effect, ask the attorney to clarify the question.
Have you been deposed
Object to
before?
form.
Object to form. Move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master. Good morning. Yes, we are in the middle of a deposition this morning.
But when the special master isn't available, plaintiff's attorney Tom Werge asks the same question again.
Mr. Abrams, have you had your deposition taken before?
And gets the same answer.
Object to form.
Asked and answered. Move on.
You need to answer the question.
The question was answered. Excuse me. Have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing you.
We're going to move for sanctions
I'm
against
asking you to
If you're not
answer
going
the
to
question.
allow
He just
her-
answered the question.
As the heated back and forth continues, Abrams, who is a witness, begins making his own objections, which a witness is not allowed to do during a deposition.
I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you.
Object to form.
For continuing to obstruct and not answer any of my questions.
Object to
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3
We're
sections.
going to move for harassment sanctions against you right now.
Things only get worse when the arguments take a personal turn.
We're going to be here for a long time today if you do not answer my questions. I can't even get through my initial questions here because you are being so obstructionist.
That's
today.
because you're a weak lawyer. You have us down here for fraud. Ask us fraud questions.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took? during this
Object to
deposition?
None of
form.
your business.
Privilege.
What are those other pills?
Object to form. Object to privilege.
None of your business. But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Object to form.
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions today. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition. as well.
Please do.
After reviewing the transcripts from the deposition, the special master issued an order for sanctions against Abram. His behavior during the deposition, along with other misconduct in the case, would ultimately earn Abrams a 9-month license suspension.
You have no evidence. Put something in front of me and we'll answer the questions. You have nothing.
Number 3.
And joking, Miss McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin.
But once you bring in my children, I think that's highly improper and it's being
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony is also improper.
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when
She
their
brought
children
up her
were
children
being
multiple
referenced.
times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Number 2.
On the 30th of June 2025, North Andover officers went to serve a restraining order against Kelsey Fitzsimmons from her ex-partner, claiming that the child was in danger. Kelsey Fitzsimmons had been diagnosed with postnatal depression. Now, the prosecutions allege that she pulled her service gun from a closet, attempted to chamber a round, and pointed it towards an officer. The gun apparently didn't go off, and she attempted again to fire the weapon, and one of the officers, fearing for his life, fired twice and ultimately struck her in the chest. She contends that a different version of events happened and she wasn't aiming the gun at the officer, but instead was attempting self-harm. The injuries she sustained included broken ribs, both lungs were collapsed, diaphragm damage, and liver trauma. She was in hospital for more than 50 days and has continued to suffer with extreme pain and difficulty breathing. Now, the judge had ordered that she have random blood alcohol testing, and the device that was nominated was the breath testing option. Now, her attorney, Timothy Bradel, requested that a bond hearing be commenced just to alter the device that was used in the testing of her blood alcohol concentration, not to do anything else, because it caused her a significant amount of pain and she didn't have the capacity to fully push enough breath and complete enough pressure to the test for it to be successful, and often it would take her over an hour to have a successful reading. She did provide a result for every random test, and she passed all of them. So they were only asking that the court authorise an alternative method, be it urine or blood testing. That's the only thing they requested. Judge Kathleen McCarthy-Newman rejected that request and concluded that without the continuous monitoring device, which is completely separate to a breath test, the Scram device is an alcohol monitoring device that goes onto your ankle and stays there 24/7, and it analyses if there's any alcohol coming out in your sweat. So that's a different device altogether. Anyway, she rejected that, and by doing so, she then said that she wasn't complying with her release from jail, like her bond conditions. So she ultimately revoked the bond and ordered that she return back to jail. Here is some audio of that hearing.
And you'll see the same thing.
So the other one, which is 9
September 9th, yes.
September 9th.
Again, at 3 o'clock. The test is initially incomplete.
At 3:09, and then it's complete at 4:21.
4:21.
So there were 2 times that she had an incomplete test. Is that correct?
Incomplete.
And what's the procedure of the probation department when somebody who has a condition of release to have scram and to pass the scram test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
So my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of an hour and 20 minutes.
That's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, actually doesn't really matter to me, but when I was doing the installation process and observed what was genuine pain, like genuine pain. So
any objection to any of the terms used by the probation officer? Okay.
So we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and she with her obstacles.
I'm getting confused. What do you mean compliant? As far as when she was initially
that's compliant with scram testing. She was ordered
when she initially was started to be monitored by scram, and you went through the preparations. Is that right?
That's correct.
Okay. So when something is incomplete, do you typically bring it to the attention of the court?
No, that's not what we do. So if something is incomplete, as in this case, at 3 on September 9th at 3:09, we have an incomplete test, which is a scheduled test.
Mm-hmm.
And then we have that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance. If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's
that's your position. That's non-compliant. It's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying is those situations you described is what you deem as appropriate to bring before the court.
It would. So I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation from our end, because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober And that's not, we don't deem that non-compliance. We never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so the schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows when she's going to be tested?
With Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule, because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens. Excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule,
With
as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I can clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing, we always default to creating a testing schedule.
Okay.
And up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the test is coming. And the test to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case, and it's done on every case.
Okay. Attorney Boyle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard Your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also—
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard what the email.
All right, so the email is excluded. Anything else, Attorney Boyle?
No, my objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, it says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that a scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
Well, if the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's for the motion to vacate the scram device. So do you have anything else to submit, Attorney Brado?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is. In light of the court releasing the defendant, that testing be done.
Okay. Attorney Brado, here, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
That depends on whether the court is willing to tolerate that the material represented in the
court is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for lack of alcohol, that's completely fine with the defense, but just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay.
But
it is not this court's intention
I understand
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that she would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes. I'll break.
Court, all right. Goes back to session, is it?
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scram, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scram. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will follow.
May I address the court?
That's the court's order. Thank you.
All right, Jack, I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.
And finally, number 1.
This is Teresa Connolly.
Opposing counsel, ladies and gentlemen.
Now,
Sorry, I have this.
before we go any further, there was a pre-trial motion noted that the M word, being MURDER, was not to be used within the trial, and it was at the defence counsel's request that that word not be used. So let's proceed to her opening statement, shall we?
Difficultly. Excuse me. I also took notes because I'm covering quite a bit. Precious little Mercedes LaSoya was killed on February 7th of 2022, excuse me. Under Texas law, we recognize killing a person as murder.
Well,
no murder.
there's one.
I'm going to object
30
that
seconds
she's
in.
violating her own motion in limine. Sustained.
The murder, I'm just
there's
reciting
two.
what the law is. Crime.
Can we approach Judge?
No, the objection is sustained.
She's murder of someone 10 years of age or younger.
The objection has been sustained, counsel.
Sorry, I can't mention murder.
Objection.
Because they didn't save Mercedes. Didn't save her life. He was the hookup boyfriend of Katrina, the mother. He hadn't adopted the children, didn't live with the children, let them stay there for a couple weeks, but that was it. CPS had investigated Katrina for years. They have pages and pages of records against Katrina.
I'm sorry to interrupt again. I'm just going to object to argumentative.
All right, that'll be overruled.
San Antonio police didn't save Mercedes. There were piles of reports against Katrina. I say PD didn't save her life.
Prosecutors'
Right?
faces.
This case is not charged as a word I'm not allowed to say, homicide. It was charged as abuse. Now, the evidence that the state provided to me, and almost everything I received from the state. The fact is, Mercedes had asthma. Mercedes.
Just on that note, as we go through the trial, this woman is absolutely obsessed with the fact that Mercedes was diagnosed with asthma when she was 1. The medical examiner testifies that there was no evidence of asthma and it was not a contributing factor at all. And yet this attorney focuses on asthma and asphyxiation and is so narrow-minded and hell-bent on focusing on that her questions are bizarre, irrelevant, and just, you'll see.
6-year-old sister Jordan had a front row seat for everything that happened.
That's probably the only true thing she says the whole
Her
time.
sister and to her. They were living at the time on February 7th at the apartment of a friend, Jeanette. I believe she's going to be one of the state witnesses. They didn't have any place to live because she had been thrown out of everywhere. Jordan said that day that her mother was, Jordan's word, jamming food.
Once again, basically this woman's entire opening statement is based upon this statement that an 8-year-old girl made 2 days after her sister had become unalived, basically, made to a CPS investigator or Child Protective Services in the US. And this statement was never produced throughout the entire trial.
Down Mercedes' mouth. Mercedes kept spitting it up. She was being gorged, kept spitting it up. Katrina got mad, according to Jordan's statement. I wasn't there. And she said she jammed the spoon down her throat.
The medical examiner later testifies that there was no injury to Mercedes' throat whatsoever to support or substantiate that claim.
At that point, Mercedes, who had been on a chair, fell off the chair. According to Jordan, she had no breath. Katrina went down to the floor and tried to give her breath, at least twice, but Mercedes had no more breath. According to Jordan, at that point, Mercedes was picked up by her mother, and they didn't go to 911 call. They didn't do anything. They ran to Jose Angel's apartment, which was in the same complex. Apparently, he tried to resuscitate her too. He tried, according to Jordan, tried to give her breath. She didn't have any more breath. After that, Jose took Katrina and Mercedes' body to the hospital. Now, they were all the way up by Huebner Road. I'm assuming you all know that general location up by 10. They went to a hospital on the far south side, which is now closed. It was the Texas Vista Hospital.
The importance of that is that from Jose's apartment where they were located to the hospital that they took Mercedes to was a 25-minute drive away, and they passed at least 5 other hospitals and a another emergency medical centre on the way to that particular hospital.
According to the reports from the ER, Katrina came running inside holding Mercedes' dead body. They didn't pronounce her dead right away, but they acknowledged that her body was lifeless and cold. Katrina told Jose to stay in the parking lot because her father didn't like him, and the father was at the hospital when they got there. She was screaming, "Help my child, help my baby." The ER people attempted resuscitation at least 3 times, which they're required to do, but there was never any hope. The charge nurse testified, or rather made a statement, that he actually pulled food out of Mercedes' mouth. Jordan was brought to the hospital by the police or somebody after Mercedes was taken there. And when she was interviewed, she said, "I'm the good child." They took her to the morgue. Mercedes' battered little body. The medical examiner did an autopsy. His basic cause of death was murder by muscle collapse. I'm sorry, I took that word. Take that word back. I'm sorry.
Excuse me.
Homicide.
Excuse me. All right, the objection will be sustained. Defense, this is what you all requested, that that term not be used.
Yes,
So
thank
you're not allowed to use that term, counsel.
Thank you, Your Honor. The ME said there was muscle collapse, and that was the cause of the child's death. But he didn't rule out asphyxia. And that's something I've been working on because I believe it was a matter of asphyxia that caused her death, based on the testimony of
You're a
Jordan,
medical examiner
the
now, are
6-year-old
you?
child.
I'm going to object to argument, Deb.
Sustained.
She's going off Jordan's statement to make that claim.
Now, Jose has been charged with various counts as they were just read to you. The state's main witness is Katrina Mendoza. She pled guilty to 1 count of serious bodily injury, but not that she did anything, that she failed by omission.
Object to argument.
Sustained.
Not that she did anything but omission.
Just ignores the judge.
Argument. It's the same statement.
Sustained.
She was tried. There were many charges, but ultimately pled to omission. Now, judge records and publishes everything that goes on in this courtroom. Normally, we don't have to.
Sustained. Ladies and gentlemen, I'm going to ask that you step outside the courtroom briefly.